Good afternoon, everybody. I hope everybody's having a good day, enjoying this beautiful weather. It's a little rainy outside, but make the most of it. Welcome. Um, my name is Nee from YZE Group, of course. As you all know, YZE Group is a privately owned real estate company, and we specialize in acquisitions, renovation, sales, and leasing of real estate in New Jersey. We've been around for a while, so we have a lot of experience. And today we wanted to talk about big news for landlords. We're going through a time now, COVID-19 period, where there's a lot of uncertainty, there's a lot of unhappy people, there's a lot of crazy people, and everything else. Most importantly, stay safe. Um, you know, Maintain your 6 feet when you go out if you have to. And but yeah, we just wanted to touch base with the landlords and let you know what's out there for you guys. And I wanted to introduce to you Linda Strauss. She's the attorney today, and we've been using her since 2016. She's very reliable. She's very knowledgeable, and she really, really knows her stuff. And she's always available to answer any questions. Um, and that's about it. Linda, over to you. Can you?
Sure. Sure. Thank you. I'm Linda Strauss. I'm an attorney. I practice throughout New Jersey. Among one of the things I do is landlord-tenant cases. And everyone will tell you the pandemic is unlike anything we've ever seen. And I'm going to go through for a little bit discussing why it's unlike anything we've seen. I have about 18 years of experience. I've graduated law school and I clerked for a judge in New Jersey, and then I've worked for various firms. I right now have my own firm with 2 offices, and we practice all throughout New Jersey. Other things that we practice as well is civil litigation, family law, estate planning, administration. But today's topic is only going to be about everything related to the current landlord-tenant issues. With that, I'm going to start. We've been placed into something that's unlike anything we've ever had before. On March 19th, which was actually fairly late relative to other states, the governor issued Executive Order 106. And what that did was create a moratorium of all residential evictions. What does that mean? It means you can't evict anyone. It means you cannot go and get someone evicted. Now, when I say go and get someone evicted, there is a little bit of a fine line because the courts hadn't yet closed officially at the time that the eviction moratorium was created. So the courts, and I'm going to discuss how there's a little bit of a loophole later on, but the courts don't prevent you from from filing for an eviction. It's the governor that's not allowing for you to lock someone out. So what does that mean? It's been in effect since March 19th, and it'll continue until 60 days after the end of the state of emergency, unless there's an order that ends the moratorium sooner. So let me simplify this. If the state of emergency ends today, we will not be able to evict a single tenant until approximately July 28th. If the state of emergency doesn't end until July 28th, we won't be able to evict anyone until September 28th. So as you could see, this is really going to be delaying the process. And I'm going to, again, discuss with you how the courts are getting so backed up with the process that we have now numerous weeks, at this point, 2+ months, by which we have not been able to lock any tenants out. This only applies to residential tenants, okay? But again, there's going to be a little bit of discussion afterwards regarding the court process. So the moratorium as far as an eviction is only with respect to residential tenants. The current state of the courts, let me describe this to you. And one of the polls that we didn't take was, where do you have your units? Anyone who has a unit in Essex County is very well aware of the backlog on any given day. They have well over 50,000 eviction filings a year, 50,000 landlord-tenant complaints. That means for every week that the court has been closed, approximately 1,000 cases haven't been heard. So we are right now in about the 9th week that the courts, we're actually entering the 10th week, that the courts have not heard landlord-tenant cases. That means there's a backlog of well over 10,000 landlord-tenant cases that have not yet been heard. So what do? There is a strategy here to get this moving along, hopefully. And the strategy doesn't have anything to do with me knowing anyone to get your case heard first. Ideally, see if you could work something out with your tenant. If your tenant owes you money, the best scenario for you and the most likely event for you to recoup any money is speaking with your tenant and see if they will pay something in the form of a stipulation. Sometimes I recommend to my clients, let's put it down in legal terms. Let's use an actual legal caption so the tenants realize the severity of this. Otherwise, if we can't work something out, file now. Filing now is an interesting situation because the courts, as you all know, were never set up for electronic filing of landlord-tenant complaints. In fact, they resisted it because they knew what a backlog it would create in their clerk's office. Every landlord-tenant complaint needs to be printed 5 times. It needs to be mailed out. And they were always reluctant, always told the attorneys they will never go electronic in landlord-tenant court. Well, here we are. And seemingly overnight, they actually created a system for us to file it electronically. We don't need to mail it in. By the way, as an aside, you still can mail it in because there are people at the courthouse, very skeleton staff. But you can file electronically. And with filing electronically, you get your docket number. So anyone who's ever filed for an eviction knows the docket number sort of means something because the calendar call very well may be in the order of the docket number. So if I filed last week, the docket number I get last week is going to be lower than the docket number I get today. That means when and if the courts are back in session, the one that was filed earlier will have an earlier court date, which means that if you have a tenant who hasn't paid and you can't work something out, let's file something immediately. Without filing it, you're going to be waiting a very long time. There's also a lot of discussion amongst the attorneys as far as what would it look like when we return to court, because as you know, a landlord-tenant courtroom is generally packed. Nee reminded us about social distancing. It is not possible in a landlord-tenant court. We don't know what it will look like. We don't know when we will come back. We don't know if it will be this year in 2020, or if they're going to do something modified later on in the year and then get us back maybe next year. But no one has discussed coming back into the courthouse yet for landlord-tenant cases. That being said, if someone owes you something, a tenant owes you some money, work it out with them. If you can't work it out, file. File as soon as you can. You will not have a court date. You will not get a court date until the courts reopen. And even then, you may not get it right away. But you know what the benefit is? You're going to have an earlier bakery number. Think of going to the bakery and collecting a number and waiting online. Your number is going to come up sooner than someone who waits. And that's going to be the tremendous advantage for any landlord who hears this advice from a lawyer, because the landlords who don't hear it are going to wait until the courts reopen, and they're going to be disadvantaged because they're going to have to wait a very long time for their case to be heard. Now, security deposit. A couple of you had responded that you're aware that the tenants had asked already about using their security deposit for rent. Guess what? Governor Murphy decided to pass something on April 24th, allowing the tenants to use their security deposit to offset any rent that is owed. And you know what the bigger problem with this is? We have no way of getting it back. The tenants have to notify you in writing or electronically to make this request. That would include a text message, an email, a handwritten note, or a letter mailed to your management office saying that they want to apply their security deposit to rent that is owed. The security deposit cannot and will not be replenished until the later of one of the two, renewing the lease or 6 months after the state of emergency is lifted. So I'm going to give you an example so you understand how long one would have to wait to see the security deposit replenished. Let's say today, May 28th, the state of emergency is lifted. Okay, and let's say the tenant's lease is up on July 31st, and she's going to renew it. So you cannot ask for the replenishment of the security deposit until November 28th, not August 1st, but you'll have to wait 6 months after the state of emergency is lifted. Conversely, if you have today is the end of the state of emergency, and the tenant's lease is not renewable until March 1 of 2021, the tenant will have to replenish the security deposit the later of, which is March 1, 2021. So this is a very dangerous proposition. The unfortunate thing is that landlords have no say in this. Landlords cannot say no, and they cannot refuse it. This is something that tenants are going to be allowed to do. Now, I know a few of you had said that your tenants had asked to apply their security deposit. Does anyone want to say if they responded in any way?
Sorry, I missed that, Linda. Say that again.
Does anyone want to say if they responded to the tenant's request in any way? Did anyone, let's say the tenant had made this request. Did the tenant, if the tenant asked for the security deposit to be applied, did anyone respond to it? Did anyone allow for it, not allow for it, or anything else?
We can either, if you want to, anybody wants to answer that, you can either raise your hand or put it in the Q&A. Hit the Q&A button.
Q&A, that's all right. Okay. I see there was a question asked a couple minutes ago by John, the eviction to a tenant. I'm going to get to all the questions after I'm done with the presentation, okay? So as far as the security deposit, we have no choice but to allow them to apply it. It's, again, this is not something that's beneficial to homeowners or, in your case, owners, managers, but we have no choice. Court dates during the state of emergency. If the court date has been scheduled during the course of the closure of the courts will mail you a notice with your new date. I have had numerous cases scheduled during the time that the courts have been closed for the past 9 to 10 weeks, and I get a new date. Oftentimes, those new dates have been rescheduled while the courts continue to be closed. Nevertheless, the courts know that they have all these cases that they haven't heard yet and have to be rescheduled, so have no fear. You'll be on their calendar when they reopen. While landlord-tenant court is suspended, do not go to court. If you do not have a lawyer, do not go to court. Do not ask your lawyer to go to court. Court is not open. There are no courtrooms that are hearing cases with the litigants or the parties or the attorneys present. You will not be penalized for not going to court. Don't let your tenant push you into believing that they're going to go to court and they're going to raise XYZ issues. There is no judge listening to their case these days. Rent increases. Now, this has been an interesting question that has come up amongst a few of my clients. And it's interesting how the tenants hear certain pieces of the news and seek to apply it to their situation. So in this particular case, I had a landlord whose tenant was up for a lease renewal, and she said to me, why is the tenant telling me I'm not allowed to raise the rent? So New Jersey Housing and Mortgage Financing Authority is suspending rent increases at their properties, which includes 36,000 rental units. It doesn't include your rental units unless you have one of their properties. Okay, so to be clear, if your tenant's lease is up for renewal, you are in the same position as you have been at any other point in time when your tenant's lease is up for renewal. Okay, which means that you can seek to renew it. You can increase the rent at whatever rate you want, but you are not in a position to have to freeze their rent. Now, with respect to tenants who owe you money and maybe you want to keep them there because you're hoping that one day they'll be able to get assistance. My understanding is that the rental assistant offices are still open, meaning that these individuals who are claiming they can't get assistance because of the current pandemic is inaccurate. Why is inaccurate? Because they're at this point able to go ahead and go get whatever assistance they want to meet with whomever they need in order to get the rent to pay you. So I think that I know the tenants, again, like hearing certain parts of things, and then they come to you and they say, I heard this, or my friend told me this, or my neighbor told me that. I think you have to have a very firm response to them, which is your rent is due. There's no rent moratorium. There's an eviction moratorium, but no one has told them they don't need to pay rent. That has come out from certain tenants in some way because they believe that because they can't be evicted, they can pay. One other tactic that I don't have a slide for because this is something that really has been, I've been kicking around with some attorneys. We don't always recommend this idea. And this is something that the more I thought about it, the more I was thinking this could be something you guys could do, which is if your tenants owe you rent and you want to keep them there, you could always file a special civil case against them. A special civil case against them, not in landlord-tenant court, but in court where they owe you a certain amount of money. If they owe you money, you can file against them as if they've breached your contract. This will not be an eviction case. This will be strictly for money, which means you will not get them evicted. But because there are no evictions, it's kind of going around the eviction part of things, because what you potentially could do is get a money judgment against them because the money judgment cases are proceeding. So I'll give you an example. Landlord has a tenant. Tenant owes money. Tenant owes $5,000. Tenant is not moving out. We have no means to get tenant out of the unit right now because we have a moratorium. So instead what we do is we sue tenant in small claims court. And we say, tenant, you owe us $5,000, pay up. Just so you know, landlords, while that case is pending, we have no ability to get her out. And we're allowed to have that case pending seeking money at the same time that we try to evict the tenant. The only problem is right now our hands are tied, so we can't get her out. So instead, what we're trying to do is just get the money. Oftentimes, my clients don't like that, and I don't recommend it because more often than not, these are tenants you don't want in there. Once they're not able to make the rent payments, they're unable to make rent payments, and you just ultimately would need them out. So while you can proceed with a money judgment or case against them to get the money, it's not always the preferred strategy. It becomes something that you still have the tenant who's not paying, but you have a piece of paper that has a judgment against them. That piece of paper is only worth as much as it is when you could collect on it. So really right now, the landlord is just, you're in a position where you want to try to collect whatever money you can. Another tactic that some landlords want to use is they contact me. They say, write a letter to the tenant. Tell them they owe this amount of money. And when the courts reopen, we're going to file. And I say, why not just file now and mail them a copy of the complaint, even if we don't have a court date? And that's often what happens. But again, we don't have a court date. So that's pretty much what sums up where we are right now with the courts. Unfortunately, as we sit right now on the landlord side, our hands are a bit tied. The tenants have gotten a very good bargain during the course of this pandemic. They've gotten a lot of protections. A lot of it has to do with the unemployment rate. A lot of it has to do with the fear of homelessness and being unable to place them anywhere else. So we have a position where the landlords are really left holding an empty bag. And I'm here to protect you to file as soon as we can, but there's no magic that we can do in terms of getting your tenants out if they don't pay. So I'm going to go to John had a question, the eviction of a tenant. Okay, so John, are you there?
I don't think you can hear him, but yeah.
Okay. John, are you there?
You can? John, John, hold on 1 second. I think I'm gonna. All right. I'm sorry, Linda. Let me just. It's thinking.
Okay, well, John, I read your question. So it seems as if, and hopefully we'll be able to unmute you in a second. It seems as if the tenant who you're talking about was scheduled for eviction. The eviction can't happen while there is this moratorium in place. The moratorium started on, it was March 19th from the executive order, and we won't be able to get him evicted until after that's lifted. And then after that, 60 days. So we have the state of emergency needs to be lifted and then 60 days thereafter. So I'm not sure that it being a former homeowner makes any difference at all. Unless you're asking about an ejectment proceeding, which I believe there's also a stay. It falls under the same eviction one. Let's see. Did we figure... John, are you there?
Can you hear me?
Yeah, we can hear you.
Okay, great. It was a final judgment from a tax lien foreclosure, and I was notified on the 13th of March, Friday, that the eviction was going to be put on hold, and it was scheduled for Monday, March 16th. So I heard what you said about this huge delay of evicting tenants, but is it going to be the same sort of situation for evicting the former homeowner?
It's actually a really interesting question because it goes to something that's a little bit more complicated than what we're addressing right now, which is the court officers and the officers who have to perform the evictions. They believe that they would be in violation of the law by locking anyone out. Even though the executive order, it didn't necessarily extend to an example like your case. In that case, while you may be entitled to have him locked out and have the officer show up and lock out this tenant or this former homeowner, the officers won't do it. So the long and short of it is there's going to be the same delay for yours. But the hope that I have for you is that you're a priority because you had like the earliest bakery number. You're top on the list now.
So, and thank you for your answer. So just to be clear, when they do reopen this, and I was told that it might happen, well, actually the representative I spoke to at the county level told me they're going back full time on June 9th. So just say
there's a difference between going back full time with the courts going. The courts have been in operation since they've left the building. I don't know even if them going back full time will make any difference because the executive order was written that it's not contingent on the court's operation. It's contingent on the state of emergency, which means that all lockouts are based on when the state of emergency is lifted. So the fact that they're going to go back, which, by the way, we keep hearing different dates. I heard April 23rd, if that gives you any context for dates that are being thrown out there by different individuals. I've heard June 1st also. As recently as last week, in fact, I heard June 1st. So I don't know that there's a date certain, but getting back into the courthouse isn't the issue. It's the state of emergency being lifted so that the eviction moratorium and the lockouts can continue, which is, I think, what you need. Now, my recommendation to you would be to contact the tax court and confirm that you have to wait, or if there's a way to have this done otherwise, because I'm wondering if there's a way for you to override the officers not feeling that they cannot do the lockout. Because that's the concern, that they're all saying they're not going to do it. They don't want to be in violation of an order.
Okay.
Thank you.
Yeah, that's some insight. Thank you. Appreciate it.
Thank you, John. Linda, real quick, on everybody on the call, I know we talked about rent increases. The rent increases kind of vary by town. So if you have any questions about the percentage increases or what you could do once your tenant's lease is over, just contact your local township. They will tell you what percentages you can increase by. I'm going to continue. And
Great advice. Hold on. Great advice. I just want to say one more thing about that. even though the courts are not in session and we may think of offices being closed, people are in the town offices. You need things from them, whatever information you need, whatever documents you need, they're there. Sometimes it requires you calling in advance and telling them what you need, and then someone will get back to you or they'll send you the papers with a little bit of a delay, but they're definitely operating. So Nee had very good advice. Just call the town.
Yeah, to add to that, personally, I've dealt with issues where townships haven't picked up, but because there's a skeleton crew, very few people working, but eventually they'll get back to you. And there was one town that said, if you need to drop anything off, just put it in an envelope and drop it off in our mailbox. So they are working, just
Yep.
a little slower than normal. They would like. All right, thank you, Linda. We're gonna go on to. Linda. I'm gonna take over the questions, and then you can, if you don't mind answering. All right. So Sharon has a question. It says, "Let me understand. We should be filing for tenants now for evictions, even if we cannot go to court." That's the question.
101%. Absolutely. Certainly. Because if your tenant hasn't paid, you're owed the money. So there is no reason not to go to court, even though you don't have a court date that you will be assigned, or you may be assigned one that won't happen. You certainly should go. It took the state a little bit of time to figure it out, but they got it. We can do electronic filings. And if you guys want to do it if you don't have a corporate entity, if you own your properties as an individual and you want to file individually, let me know. I'll send you the links that you need.
Sharon, are we good? Do you have any more questions? Yeah.
Actually, I do have another question. Now, this is in regards to any other type of tenant, like a tenant that I'm having issues with, and I'm not renewing their lease, so I'm actually filing for their eviction. This goes for them as well, correct?
The holdover, you mean that the answer is yes. You should file anyway. And the eviction moratorium will still continue and still applies. They are making some small exceptions for having eviction proceedings held now, which is essentially if your tenant is destroying property or committing a crime on the property.
Exactly. That's what I'm referring to.
You are referring to that, as I was saying?
Yes.
Okay, so I had this conversation with a client yesterday, and my recommendation was when you file it, it has to be very thorough. Meaning, if you have police reports, we're going to attach a police report to the complaint. This is not going to be your average landlord-tenant complaint because you don't want it bouncing. You want them to hear it. And I would recommend also contacting whatever county it's in, letting them know that this is what you're filing and why it needs to be heard on an emergent matter, because you don't want to wait 60 days post-state of emergency.
Okay, thanks. Yeah,
sure.
I needed to hear that.
Thank you, Sharon. I have a couple questions for Linda, if you don't mind me asking. Linda, so my question is, I heard judges are talking about forgiving past rent. Is this true? Can they do that?
I have not heard that. So I don't know if it's true or not. And I would guess that the answer is basically no, because they can't rewrite the contract for you. But I wouldn't be surprised if what ultimately happens once we get to court, if a tenant didn't ask their landlord to apply their security deposit, that the judge allows that to be done. Okay? So I do anticipate that the judge having a lot more leeway. The judge has never, ever allowed a tenant to do that before this. I'm expecting that in the future, the judges will allow for the tenant to retroactively apply their security deposit.
Okay. Thank you. Another question I had is, do you know if there are any programs? I know you briefly mentioned that landlords are pretty much SOL right now. Excuse my French. But do you know if there are any programs that are coming out for landlords to protect us? I heard Newark has something going on where if the tenant can actually prove that they owe the landlord money, I guess an agency or whatever would pay. But I'm not sure how that works. Do you know? Are you aware of it?
So, I'm sorry.
Go ahead.
Did you finish?
Yeah, I'm done.
So that's actually a great question because I touched upon the programs that are available. Let me make this clear to you. Some of these programs do not pay for rent owed until the tenant can prove that rent has been owed. How better to prove rent has been owed than to file a complaint against the tenant, which means that you have filed against the tenant. They now have the complaint which says they owe rent from February, March, April, May, June. And at that point, they can go to the agency and say, here's proof that I owe rent. I need your help. So it's actually a great kind of segue for us to move from landlords are SOL, but what can we do to help ourselves? File. Why? Because number one, we can get back to court faster, hopefully. And number two, this is giving the tenant something to bring to the agency, which would hopefully provide funds for us. Because the agencies don't pay on back rent unless they have proof that it's owed. That is correct. And as for what the landlords are doing, SOL is yes, I would agree with that for the most part. But there is talk amongst the lawyers to try to get this moving from a political standpoint, that the landlords really got screwed on this, pardon my language. And our hope is really to put pressure on politicians to make the changes necessary to either provide relief to our landlords or to open up the courts to the cases.
Okay, thank you. So do you know of anything? I guess it's all rumors now. There's nothing in place, right? That's correct for landlords?
For the most part, we would say that it's rumors. I mean, I know that there is I don't want to say it's rumors. I know firsthand that people are talking about it, what our steps are going to be. We do want to be proactive. I've heard it also in New York that there are hot spots that the lawyers are trying to gather up and to really put pressure on whoever it is, whether it's our politicians or whether it's the courts, to get the landlords into a better position.
Okay. Thank you, Linda. I think I have a couple more. There was a question about the security deposit again. Can you just quickly go over that, how to apply, like for them to pay back the security? If the tenant decides to use the security that they have with the landlord, how do they pay back the security? Just to make sure that once they move out, you have something to go by.
You don't.
You don't. Okay. So
what happens is as follows. Tenant notifies landlord today in writing, please apply my security deposit to my June rent. I won't be able to pay rent. Okay? Because now it's the third month that they're in a quarantine. It was April, May, and June. So we're really heading into the third month that maybe they won't be able to pay the rent. So they notify you. They say, I want to apply my security deposit. And after this, they'll have no more security deposit left, right? So what happens? They move out then in August and there's damages to the property. And the answer goes back to SOL. You have nothing to protect yourself. Wow. And the odds of them moving out prior to getting a replenishment of the security deposit is frightening, because it's the later of renewing the lease or the 6 months after the state of emergency is lifted. So right now, the landlords are being left in a position where they don't have a security deposit in place for these tenants. The law, the executive order was written that the tenants should basically behave, leave the property in good condition. Don't make the landlords stand there holding an empty bag trying to repair their unit after you live there without having security deposit in place. So it's, again, not beneficial to our landlords, not protecting our landlords, the taxpayers who are paying tremendous amount of property taxes on these units. But this is, I think the mindset at the time that it was written was the state of unemployment in New Jersey, where this was going, how many people would be unemployed, the jobs lost, unfortunately, the death toll. And that's why these were written this way. But it really leaves the landlords in an uncomfortable, difficult position.
Thank you, Linda. Just FYI, I don't know if people on here are aware, but it's obvious that some tenants are just trying to take advantage of the system and not pay, and some legitimately could not pay. Now, those who are furloughed or don't have any jobs right now, most of them, if they have received, so one of the issues is people are still waiting for their unemployment checks that they applied for months ago. Now, the average, I believe, the minimum you can get for unemployment right now is about 200 and change, and they add the additional $600 per week. So that's about $800 net that people are getting from their unemployment. I so that goes to say, I mean, even if they can't pay the whole rent, they can pay something, you know. So the best thing, like Linda said, is to speak with them one on one and see if you can encourage them to pay. That's
Work
probably
something out.
work something out. Exactly.
Work something out. And really, you know, I'm a litigator. I like litigation. I've always wanted to be a lawyer. I love what I do. But now is not the time to get really down and dirty and fight them. Now's the time to try to be their friend. And the reason we do that is because you have no other means of getting money from them other than trying to gain some friendship with them and trying to relate to them as a person. I know commercial landlords, they have several strip malls. And on March 24th, they sent an email to each and every one of their tenants saying, given the current situation, don't worry about April rent. Come back on May 1st. Let's talk. If you have a problem, let me know. And the truth is, a lot of their tenants paid part of April. But if you don't reach out to your tenants and just file, the problem is we have no means of getting them evicted and no means of getting you money. And you guys are in this for a business. It's not gratuitous what you're doing. So if we could get you some money and still file against them, great. If we could get you some money and you don't need to file, even better. But if we get you no money and just file and we sit there and wait, you guys are sitting on a dead investment. And I don't want that for any of my clients. I want you to recover some money from this.
All right. Thank you, Linda. Does anybody else have any questions about this whole webinar and the COVID-19, everything that's going on? I'm sorry. My landscaper is now doing his job. Hold on one second.
I sent mine over to you, my neighbor.
I know, right? All right. So, yeah, sorry about that. Does anybody have any questions? You can either raise your hand or put it in the Q&A. I see a question here. Hold on one second. Oh, it says, thank you for your insights. Thank you.
Thank you.
All right. So thank you guys for joining. Linda is available for one-on-one consultations. Her information, phone number, email is on the bottom of the screen. If you could see bottom right. If you need to contact her about any questions, please feel free to do so. And if everybody can look out for future webinars, thanks. Okay. If everybody, I'm sorry. Thanks for this is accepting new clients. Oh, yes. Sorry. So that's a question for Linda. So if everybody can keep looking out for webinars. We'll be having more shortly, and we'll give you some more valuable information. Linda, there's a question for you.
Yes.
It says, thanks for the webinar. And is Linda accepting new clients? I run a 42-unit building. Sharon, I can answer that. You can come through me. I'll take a commission. No, I'm just kidding. I'll hand that over to Linda.
Yeah, I'm happy to assist you. Yes, I'd be happy to. And you can certainly reach out to me off of the webinar and we could discuss how I could help you.
All right, guys. So thank you so much, Linda. Valuable information. Thank you so much.
Thank you for listening.
We're ready to go conquer the world with our tenants. God bless you. And everybody have a great day and stay safe.
Stay safe. Take care.
All right. Bye-bye.
Bye.
I don't like the way this thing